So we're going to talk about racial desegregation in other areas and see what it looked like. And the other area that I'm going to focus on, and we're going to do one case in, is in terms of housing. Um, so housing kind of buttresses this idea of school segregation. If within certain areas, African Americans were unable to buy houses, and since we know school districts come from a a very localized nature, that housing would help keep schools segregated even if there existed no laws on the books which actually made schools segregated. Um, there were successes here against legal prohibitions up until 1968. There was a lot of success, but de facto discriminatory housing still existed in the U.S. And that was largely until the Fair Housing Act of 1968. Um, the court says that the Civil Rights Act of 1866 already prohibited it, striking down the Civil Rights Act of 1968, nor can rights of minorities be put up to public referendum. And so what we have is there's this thing called selective covenants. And selective covenants you may have heard of. The reason why I say you may have heard of is they still come up in the news not infrequently. There was an example earlier this year of a family in California who bought a house only to find out that that house was part of a selective covenant area. So what is a selective covenant? Well, a selective covenant is basically a contract created by usually what we would consider homeowners associations or groups of like-minded homeowners within an area. That is an agreement that they refuse to sell their homes to individuals of some form or some prohibited race. In California, it was individuals who were of Hispanic descent. So they were prohibited, that the houses covered by that selective covenant were prohibited from being sold to individuals of Hispanic descent. Primarily within the Midwest, the South, and really the North and Northeast as well. These selective covenants were designed to keep African Americans out of particularized areas. So these selective covenants really only get into legal trouble when they have to be enforced. And here's the thing is, if everyone agrees to this selective covenant, if everyone in the area signs on to it, then they're all in agreement that they're not going to sell to a particularized race. That's just outright discrimination, but it violates really no law, no standing law, because it's privately based discrimination. But once you start selling houses and whatnot and so forth, you'll get owners of a particularized home that never signed on to the selective covenant or the original selective covenant. And the question remains, are those individuals bound by the selective covenant? And if they are bound by it, will a court enforce it? And that's really the question in the next case that we're going to look at, which is Shelley versus Kraemer. Shelley versus Kraemer takes place in the 1940s, and it arises when an African-American family purchases a house in St. Louis in an area that was controlled by restricted covenants. In fact, the restricted covenants went so far as to cover not only African-Americans, but individuals of Asian descent as well. So it was a selective covenant. The individuals who were part of the community sought to seek a court to enforce this restrictive covenant. The problem with that is courts aren't likely to lend their voice to this. To sort of underpin the nature here of these selective covenants, when this case gets to the United States Supreme Court, the Supreme Court decides the case 6-0. There weren't any absences on the court. It's not like 3 members didn't show up. 3 members recused themselves because they owned properties which were part of restrictive covenants. to show you how wide this issue was, how broad the issue was. So there are there's really primarily two questions here, and the way that the court takes them on, it's very smart. The court takes them on in sort of a serial fashion. And the first is, are these racially restrictive covenants a violation of the Equal Protection Clause of the 14th Amendment? And the second one is, can these racially restrictive covenants be enforced in courts? And this is where this decision is pretty interesting in terms of its breadth. The court is unanimous, 6-0 unanimous, but the court is unanimous. And Chief Justice Vinson writes the majority opinion. And what he says is that these restrictive covenants are private. And as private, they aren't a violation of the 14th Amendment until someone makes a law restricting them. And in 1948, clearly the federal government had not made a law that restricted racially restrictive covenants. But the crux here comes at what happens in terms of enforcement. And Vinson says that courts simply can't enforce these restrictive covenants. And the reason for that is they lend the weight of law and government to these racially restrictive covenants, which in and of itself would be a violation of the 14th Amendment, that the state or the court in question would violate the 14th Amendment by enforcing these covenants. And so the covenants existed from this point onward in an interesting space where the covenants themselves were not illegal, but they could never be enforced by courts. And so what ultimately happened, as is true of many things, since the court was unwilling or unable to step in and simply strike down restrictive covenants as a violation of the 14th Amendment, and they wouldn't lend their weight to enforcing them, this left enforcement up to private individuals, which meant that racially based violence following the purchasing of property was rampant in the United States. Individuals would learn that they had bought in to a restricted covenant area by threats of violence, by having their houses burned, by being literally beaten out of the area. And so government inaction here proved poor in response. And so while the court would not say that these covenants are unconstitutional, just their enforcement is unconstitutional, it left these covenants in a legally precarious place that ultimately left the enforcement with the individuals who had bought into these covenants in the first place. And that led to, not shockingly, significantly more violence of a racial context in many cities throughout the United States.